Good afternoon and welcome. I am Colleen Murphy, a professor here in the College of Law and director of the Women and Gender in Global Perspectives program on campus, and it is my honor and pleasure to welcome you to the David C. Baum Memorial Lecture on Civil Liberties and Civil Rights. Endowed in 1973 by the family and friends of David Baum in his memory and at his request, the lecture series has served as a testament to the life and work of Professor Baum. After graduating from Harvard College and Harvard Law School, Professor Baum clerked for Justice Walter V. Schaefer of the Illinois Supreme Court. He then practiced at Rouse, McGowan, Hardee's, and O'Keefe in Chicago before joining the Illinois law faculty in 1963, where he taught until his death in 1973. Throughout its history, the lecture series has hosted the greatest thinkers on important legal issues of the day, and is a fitting memorial to a man whose unrelenting intellectual vigor and moral commitment made his presence in the world of law invaluable. Today's lecture is another great addition to the tradition of the Baum Lecture Series and the legacy of Professor Baum. Today we welcome Fatima Goss, President and CEO of the National Women's Law Center in Washington, D.C. Ms. Goss-Graves, who has served in numerous roles at the NWLC for more than a decade, has spent her career fighting to advance opportunities for women and girls. She has a distinguished track record working across a broad set of issues central to women's lives, including income security, health and reproductive rights, education access, and workplace fairness. Most recently, she served as the Center's Senior Vice President for Program, where she led the organization's broad program agenda to advance progress and eliminate barriers in employment, education, health and reproductive rights, and lift women and families out of poverty. Prior to that, as the Center's Vice President for Education and Employment, she led the Center's anti-discrimination initiatives, including work to promote equal pay, combat harassment and sexual assault at work and at school, and advance equal access to education programs with a particular focus on outcome for women and girls of color. Ms. Goss-Graves has authored many articles, including A Victory for Women's Health Advocates in the National Law Journal, We Must Deal with K through 12 Sexual Assault in the National Law Journal, and reports including Unlocking Opportunity for African American Girls, A Call to Action for Educational Equity, Reality Check, 17 Million Reasons Low-Wage Workers Need Strong Protections from Harassment, and 50 Years and Counting, The Unfinished Business of Achieving Fair Pay. Ms. Goss-Graves received her BA from UCLA in 1998 and her JD from Yale Law School in 2001. She began her career as a litigator at Mayer Brown after clerking for the Honorable Diane P. Wood of the U.S. Court of Appeals for the Seventh Circuit. She currently serves as an advisor on the American Law Institute project on sexual and gender-based misconduct on campus and was on the EEOC Select Task Force on the study of harassment in the workplace and a Ford Foundation Public Voices Fellow. She is widely recognized for her effectiveness in the complex public policy arena at both the state and federal levels, regularly testifies before Congress and federal agencies, and is a frequent speaker at conferences and other public educational forums. Ms. Goss-Graves often appears in print and on air as a legal expert on issues core to women's lives, including the New York Times, the Wall Street Journal, the Washington Post, AP, the Chicago Tribune, LA Times, San Francisco Chronicle, CNN, MSNBC, and NPR, so we can continue to see her even after today. Please join me in welcoming Ms. Goss-Graves.
Thank you for the extremely kind introduction, and longer than I'm sure any of you needed to hear about me. I'm Fatima Goss-Graves, and I am the very new president and CEO at the National Women's Law Center. And I say that because we are a 45-year-old organization that was founder-led until June. And in July, I stepped into this new role, and I did so at quite an exciting time. I also am just really thrilled to be here and to have been back in touch with some of my law school classmates, Professor Sharp and Professor Sharp. It's really exciting to be here with both of them, and to also have my first time visit to the University of Illinois. So thank you for having me, and it's a real honor to learn more about the legacy and the work of Professor Bum, and I hope I do him proud. So Title IX, the law that bans sex discrimination in education, turned 45 this year. And as I said, the National Women's Law Center did too. But what that has meant for us as an organization is that over the course of the last 45 years, we really have seen as part of our role as guiding and developing and sometimes guarding that really critically important law in the courts, in Congress, and through agencies. And ensuring really that schools live up to Title IX's promise of eradicating sex discrimination in education. And before I get into the thick of it, so that we're all sort of on the same page, I'm just going to talk a little bit of baseline about Title IX and a little bit of stage setting. So, it is a law that applies to nearly all schools, and that's because if you take federal funds, you have to comply with Title IX. So that is basically all K-12 public schools. That is K-12 private schools that take federal dollars, and some do, although that's not so well known. And that's nearly all private and public colleges and universities, because if you take federal student loans as a college or a university, you too are a federal financial recipient and must comply with Title IX. I won't bore you of the details of the fights that have led to that conclusion, but just will tell you that that is where we are today. And when Title IX was first passed in 1972, and we have, the National Women's Law Center has our little library, which has a lot of original records that someday we're going to get an archivist to do better by these records. But, the conversation that Congress had was really about, at the time, but what do we do with the fact that women had been excluded from a lot of educational programs, and when in educational programs weren't on equal terms? And just to give you a few examples, that for many elite colleges and universities, there were some firm quotas on admissions overall. It wasn't that they were single-sex universities. It was that they had made determinations that only a certain number of women could be in those programs. And then there were other elite colleges and universities, public and private, that just had bans on women attending. UVA did not have women until 1970. And then there were other just sort of rules where, again, firm rules that once you were admitted, there were certain programs that were male programs that women weren't admitted unless there were spaces, unless there were a few spaces. And so you see now, and there have been the stories told of women who were sort of either the first or one of a few in many different programs. And there were exceptions to the rule over time. If there was a space, or if at the last minute a man couldn't come, then they would let a woman in. And there were, even within programs, there were different rules, more restrictive rules for women. Dorm rules that were women dorm rules about what time you had to be in and whether or not you were allowed to have people over to your dorms, where male dorm rules didn't have those sorts of really firm restrictions and curfews. Pregnancy or parenthood in many schools meant the end of the road for school, that you could not be pregnant and be a student. That was just a rule in many places. And it also, if you think about faculty, and Title IX's protections against discrimination also apply not just to the students, to the community, so they apply to faculty and employees, but they were frequently denied tenure if they did things like have kids. They were prohibited from entering faculty clubs, and this time, if you think about 1972, this period of time predated a lot of really important Supreme Court case law that developed over time what it means to discriminate on the basis of sex. It predated the fight over whether sex discrimination included pregnancy discrimination in the courts, and it also predated the Pregnancy Discrimination Act, which Congress resolved that question after a not-so-great Supreme Court decision. But the bottom line is the norm at the time was discrimination, and Congress was trying to shift that across the board, across programs. And if you look at the legislative history, Senator Birch Bayh, who people call the father, or sometimes the grandfather for some reason, of Title IX, he tied this directly to economic security. He said it is critical that women have access to education programs for their economic security. So I tell that back in part to dispel a few myths that have been out there around Title IX, especially among my generation. I was sort of a Title IX generation. I never went to school without a Title IX. So it was not a law that was written just to address athletics, for example. But there was dramatic improvement in access to athletic opportunities that is really measurable. So when people think about Title IX, they often would think about, well, that means that girls can play sports on equal terms, a fight we are still having, by the way. But you could see the multiple % increase in women and girls playing sports at the high school and college level and measure that as success. So that story is often told either around the anniversary of Title IX or during Olympian years. And we're part of the people who tell that story, so it's not a bad story to tell. But it wasn't actually until the regulations were written in 1975 that there were real discussions about sports and what Title IX would mean for sports. And even in the early days, in the 70s, when these regulations were written and efforts to actually get those regulations implemented, there was also early understandings that a ban on sex discrimination included sexual harassment. And one of the really leading thinkers in developing this early framework was Professor Catherine McKinnon. And in her early work became the basis of a federal complaint that was filed against Yale in 1980 called Alexander versus Yale. And in that complaint, the students claim that their male professors regularly propositioned them for sex in return for better grades, and that they had no way and nowhere to complain to their university. And in fact, one student said that when she complained, she was threatened with arrest for libel for reporting these advances. They didn't actually seek compensation, and I can tell you in a minute why. But what they did ask their university to do was have a policy and stop it. They wanted everything to stop. So the court ruled that in this decision, by the time the students actually brought this case, that many of them didn't actually have standing to bring the suit because many of them had graduated, and that one student's claim of quid pro quo was denied because she didn't actually receive a higher grade despite engaging in sexual intercourse with him. So you have to understand that 1980, that predated the Supreme Court's really important conversation around what is sex discrimination, how does sexual harassment fit in, and what are the obligations of institutions to address it. But it's important to know, and I tell the story of Alexander v. Yale and the early work of Professor McKinnon, because this work was happening very early on, and understanding that it is difficult to access an education program through the prism of harassment and violence. So what happened, though, is even though they did not prevail in their suit is that before the suit was resolved, Yale established a harassment grievance board, and hundreds of other colleges and universities followed that lead. And they began to institute at least a procedure to report harassment. So 45 years later, after Congress passed this very ambitious statute that said you can't discriminate anymore in education, and 40-ish years after Professor McKinnon was beginning to envision the way in which harassment and violence fits into this framework, we are now in this really interesting moment. We're in an interesting moment culturally, sort of an era of the Me Too hashtag, where there's a virtual coming out of the harassment and violence that plague all sorts of institutions. I don't know if people read the New York Times op-ed by Diana Nyad today, but it sort of stirred me in a range of ways. But the names of the people and their stories who make up the Supreme Court's harassment jurisprudence are far less known. And their stories, I think, are critical in understanding where we are today and how it is that we grapple. So I'm going to talk a little bit about the three students who are at the heart of the Title IX Supreme Court jurisprudence. Their names are Christine Franklin, Alita Gebser, and LaShawn Davis. And LaShawn Davis was the National Women's Law Center client and is very near and dear to all of our hearts there. But I'll start with Christine Franklin. In 1986, Christine Franklin was a 10th grade student at North Gwinnett High School in Gwinnett County, Georgia. And Title IX had been in existence at this point for 14 years. She was a student athlete. And in the fall of 1986, her coach began a very common grooming practice that we hear about a lot and that Diana Nyad talked about in her Times op-ed, beginning to ask her about her sexual experiences with her boyfriend. And then that escalated to kissing her once when he was alone with her in the parking lot, calling her on her phone to meet her. The next year, when she was a junior, he began pulling her out of class and bringing her to his private office where he began subjecting her to multiple instances of intercourse at school. And although the school was aware that something seemed inappropriate and then aware of the harassment of Christine and had been hearing over the years about other female students complaining about the coach's behavior, they never tried to stop it or even really discourage him. In fact, they discouraged students from pressing charges with the police. Finally, after many years, he resigned. And the school viewed its obligations as done with that resignation. Where Christine fit in all of this was completely absent. And she eventually brought the Franklin versus Gwinnett County public school case, which is a landmark Supreme Court case for a number of reasons. It was a unanimous court, and they held that sexual harassment is a form of sex discrimination under Title IX. That wasn't a far reach to have that sort of holding. It wasn't that long after they had held that under Title VII, sexual harassment was a form of discrimination in the Meritor Savings Bank versus Vinson case. And that the school could be liable for that harassment, and that the school could be liable for damages for that harassment. And in Franklin, the court made it clear that Congress didn't intend to limit the remedies available in a suit brought under Title IX. They hadn't set out a very detailed scheme that said your remedies are this or that. And so a damages remedy could be possible and appropriate in some cases. And that finding is really the undergirding for all damages cases available under Title IX, but not just Title IX, also the other civil rights spending clause that ban discrimination by people who take federal dollars. So that case is often cited and noted for the baseline holding that you can have to pay damages. Several years later, there was another case the Supreme Court took up because in the Franklin case, it had said, yes, sex discrimination includes harassment, but it hadn't defined what the standards were. So that brings me to Gebser versus Log of Vista. Alita Gebser was a few years younger than Christine Franklin, but her case also dealt with teacher-student harassment. She first met her abuser as an 8th grade student when he was leading a book club at the high school. And then when Alita finally entered high school, he began starting by making sexually suggestive comments to her and eventually engaging in a sexual relationship. The school had some notice of the misconduct because parents of other students were complaining about the sexually inappropriate comments that he was making. But the teacher was never disciplined. The school never informed the school district or the superintendent. And it wasn't until a police officer caught the teacher in the act of abusing Alita in the parking lot of the school that he was arrested and fired. And so in Gebser versus Log of Vista, the court decided, though, that Title VII wasn't the precise exact comparison for a Title IX case and developed a new standard for student-teacher harassment. It's a standard that is much higher to meet than Title VII cases, and basically is that it means that an appropriate school official has to have actual knowledge of the harassment, and then the school has to be deliberately indifferent to the harassment in the face of that knowledge. So unfortunately for Alita, the court held that her school wasn't liable because appropriate officials didn't have actual knowledge of the harassment. And in the dissent at the time, Justices Stevens and Souter and Ginsburg and Breyer said, I don't know why you're straying from the Title VII model that we just said was the right model in Franklin. This is a school that failed to effectively protect Alita, and that might actually thwart the purpose of Title IX in doing so. And I think this case is really important, and when I pair it with the next case that I'm going to quickly talk about, you'll see why the work of the Department of Education has been so important over the course of time, because it's really hard to go directly to court anyway, but it is even harder under these tougher standards that Title IX requires. So the next case I'm going to tell you about, and then I promise you I'm not going to give you more detailed fact cases after this, but that is the Davis versus Monroe case. And it happened a year after the Gebser case. This time, rather than teacher-on-student harassment, it was a case about student-on-student harassment. LaShawn Davis was a 5th grade student in Monroe County, Georgia, in 1992. And that winter, one of her classmates began repeatedly bombarding her with vulgar statements about wanting to feel her breasts, wanting to get in bed with her, repeatedly trying to touch her, sometimes succeeding in touch her, and yes, she was 11 years old. She and her mother repeatedly complained to the school, to the teachers, to the principal, and they never took any actions to discipline the student, and they never took any actions to make it stop. Finally, after 3 months of complaints, they agreed to move her seat from right next to him in the classroom to the back of the room. LaShonda had been a really high-performing student, but after enduring many months of harassment, her grades dropped. She couldn't concentrate on her studies. The following year, her father discovered that she'd written a suicide note. And she said she didn't know how much longer she could keep this boy off of her. Fortunately, in this case, the Supreme Court decided in her favor. The court held that the school had indeed had actual knowledge of her abuse and had been deliberately indifferent to it. And furthermore, they found that she was entitled to harassment because the behavior was so severe and pervasive and objectively offensive that it denied her equal access to education. Here again, they applied a standard that was not the same standard as Title VII. That standard is whether it is severe or pervasive. And for LaShawn Davis, they said it must be severe and pervasive, and in this case, it was. And they also applied this actual notice and deliberate indifference approach. So, importantly, though, in that case, the Supreme Court said, we just want to let you know, the Department of Education, you don't have to apply this standard. We're applying this higher standard because we believe that when schools take money, they have to be fully on notice that they could be at this damage risk. So that's why we have this actual notice and this deliberate indifference standard. Department of Education, if you want to apply a standard that is lower and go that Title VII route that you were advocating, do it, because you have your own independent work to do to enforce this law. And that is what happened. The Department of Education said, okay, we will do our own guidance that explains what harassment is and that explains to our schools that you take federal dollars, and what that means is that you must comply with the law. And what that means in our mind is that if you knew or should have known about harassment, you have to address it promptly and effectively. So that work that happened after a lot of back and forth and a lot of notice and comment came out in 2001, and that has been the big, bulky guiding document that schools had used and thought about in for many ways. But these cases not only set the framework for guiding us around what does it mean to discriminate on the basis of sex under Title IX, but it also, as I was looking back at them, was such a strong reminder about both the acts of harassment that show up in school and the school's response once there is information. In Franklin, the grooming behavior of that teacher lasted for over a year. It occurred on school grounds, it occurred off school grounds, and in plain sight of many school officials, and yet it persisted. And many of the students that we hear from today are often surprised that no one has noticed and no one has intervened on their behalf. It makes them believe that their schools aren't interested in protecting them and that the adults in their lives must know and must not care to fix this problem. And although in Franklin the teacher was ultimately terminated, the school saw its role as ending there. But it didn't address the fact that this student, and likely, frankly, in these types of cases, other students too, had experienced harm for a very long time. So in Franklin, the court awarded damages to address that. But even still, there are a long list of supports that the students we hear from often need that can be put in place to sort of make a difference. Some of that harm is emotional, some of that harm is dignity harm, some of that harm is literally which education programs you decide you are accessing or no longer accessing because of the harassment and violence. Some of it is the long-term economic security of either being in or out. And then in the Gebser case, it was a very strong reminder of what happens when a school looks the other way. Here, the school kept hearing from parents that they were concerned about a particular teacher, and they did not want to hear it. The teacher was never disciplined, even for inappropriate comments that he was making to young students. No one beyond the principal was ever informed. This was not an issue that people thought they needed to elevate and continue to push on. Nothing happened until the police were involved. And in my mind, the facts here are a stark reminder about why this is an issue that can't just be left up to the police. It's especially the case when you're talking about younger students, K-12 schools, where students are obligated to attend and stay in school. There are rules about them being in school. But it is also the school that will see the early signs and either act or choose to ignore them. It's the school that has the ability to take action short of something violating the criminal code. And even though her school had noticed the misconduct from the other parents who complained, if they had waited, if you wait until the police officer actually catches you in the act, which is what happened here, there's a long list of steps they could have taken before to address these sort of warning signs of grooming behavior, many of which probably didn't violate any criminal law. And finally, in Davis, we saw what happens when people simply don't believe victims, when their stories are discounted and dismissed and ignored. For LaShawn, she kept trying to turn to the adults in her life to ask for help, and they really sent a strong message to her that they weren't going to offer that sort of help. It's also a reminder that both students have a lot at stake. Both the student who's named as engaging in harassment, insult, and the student who comes forward to try to complain in the first place. It should not have taken 3 months for LaShawn Disparen to get the school to take the action of kind of penalizing her by moving her to the back of the room, and that was the best relief that she could have gotten. So when I think about Christine and Alita and LaShonda, in many ways they're kind of girls before their time. They told their stories and tried to get action before there was this movement that has been fueled by student activists and digital connections and a president who said, "I was going to stand with you," student activists. And their stories really predated a new norm of attention to the issue of harassment and violence. They came before this new sort of organizing and this new understanding that there is this law called Title IX, and this cultural shift that I believe we really are on the brink of. So over a decade or more after these brave girls stood up, this second wave of activism is challenging longtime practices that schools have been grappling with for many, many decades. These students learned about Title IX and wondered why, if there's a clear mandate to ban sex discrimination, 1 in 5 women in college campuses and 1 in 5 girls who are ages 14 to 18 still report experiencing sexual violence. They've raised, if this ban on sex discrimination actually exists in reality, why are their schools failing to provide them the supports that they expect and deserve when they do come forward? And they've raised, if Title IX requires equality, why are there systems that are set up that are focused just on the students who have been accused? Why isn't there an equal right to education in practice, and in many ways an equal right to be believed? And all of this now leads me to what has now become infamous and also now rescinded 2011 guidance on Title IX sexual violence. So to understand this guidance, I just have to say a couple things about guidance documents generally under Title IX. And that is that for decades, the Department of Education, when it wants to communicate with schools about what it is they need to do to comply with the law, or sometimes a reminder that they must comply with the law, or sometimes really short, discrete, they put out guidance. Actually, Title IX has regulations that were put out in the 70s and that have been changed very few times over the years. This is not a body that does a lot of formal regulation, and that's true for all of the spending clause civil rights statutes. The regulations that were early adopted are the regulations that were early adopted, and there were very few changes. And instead, they communicate through guidance, many of them as letters that are written and called Dear Colleague, quite formal introductions. And perhaps those sorts of formal introductions are appropriate because they contain important information and sound advice and reminders sometimes of longstanding rules. And the Department of Education under the Obama administration had received a lot of requests from schools and from student survivors asking for guidance on how to address sexual violence. Part of this came after a detailed investigative report that had been published detailing the many ways that schools were failing their students, some pretty shocking stories that were elevated in the press. And some students were just learning at that point that there was this thing called Title IX that applied to something other than sports. So the department issued in 2011 a Dear Colleague letter, and it said, schools, you have to actually investigate any reports of sexual assault, and you must do so promptly, thoroughly, and fairly. It also said, schools, this isn't a process that you can use to re-traumatize students. So that, after all, that would kind of defeat the whole point and purpose of Title IX for the school to be allowed to engage in that sort of conduct. And so just to give you some examples of what that meant, that it was a reminder that you can't just tell a survivor to sit down and work things out with their rapist in mediation, that some things can't be mediated. It also said, on cross-examination, we discourage you from having one student cross-examine the other in your processes. So cross-examination is allowed, vetting of information, of course, is allowed, but they said, bad idea to have the person who you just said raped me question me in that way. And in order not to re-traumatize, they said you need to consider only the information and evidence that's actually relevant to the investigation. So that meant that you shouldn't spend your time questioning people about their sexual history, and it shouldn't be a lot of stuff that has long been dismissed in other contexts as irrelevant, and it shouldn't be a forum to ask a lot of questions about, well, why did you wear such a short skirt, and what are you doing here looking like that, and do you date too many people? It also said you have to make some accommodations while an investigation is ongoing. And those might show up in a range of ways. Sometimes it's changing classes. Sometimes it's changing dorms. Sometimes it's coming up with mutual agreements about if we both show up to the same place, we're both going to leave, so that you don't have to constantly share the space with the person who you just said raped you. And finally, it focused on fairness, as an equality statute should. And it required schools to make the same rights and opportunities available to both sides. So if one side was allowed to appeal a framework that was unfair, the other side must be allowed to appeal that too. And highly controversial, it emphasize that the standard that applies to civil rights claims, which is the standard that applies to most civil claims, is the preponderance of evidence. And that it is a standard that allows both sides to be believed. It is a standard that says it's more likely than not that one side or the other side is right, that is how you make the determination. It shouldn't be a surprise that most schools were actually using this standard before the guidance, but some were not. And for those schools, they did not like changing those standards. But it's important, again, to remind that it's the standard that's used in nearly all civil proceedings overall. So the guidance served as a really important reminder, and it used this equality framework that led to many survivors coming forward. And instead of being dismissed or punished for coming forward, they actually had an opportunity to be a part of a process where they could make their case. So all of that brings me to where we are today. And just in September, the Department of Education rescinded this guidance document and told schools in a lot of ways, issued an interim document and said in a lot of ways, on a number of these things, you can do what you want. You can either use a preponderance standard or another standard. That's okay. If you want to allow cross-examination without limits, that's okay. If you want to have one side appeal and not the other, that's probably okay too. And we'll be back to you with something more formal. And if you want to have mediation, fine by us. So this, in many ways, people worried was going to really disrupt the progress that we had been making. People worried, including me, that survivors would be subject to invasive and irrelevant questions about their sexual history, that they'd be forced to participate in mediation with the person they said that raped them, that they would receive direct cross-examination from the person they said raped them. One student we heard from who we're doing some work with said in her proceeding, she was asked to list every single boy she had ever called a boyfriend going back to when she was 15 years old. She wasn't sure how that was related to the very specific complaint that she'd made, but it made her feel a little uncomfortable to have to create this list and name all the people she'd been in relationship with for the last 7 years. So we're in this period of time where, unfortunately, I think, for schools and for students and for campuses, that there's a lot of confusion about what it is they should be doing, what it is they're required to do, and what it is that they should do going forward. And I think we're going to see a lot of schools making mistakes and in ways that hurt students. And for organizations like mine that have been working to guide and guard and advance Title IX and really advance opportunities in education for women and girls, we feel like we're in one of the biggest fights of our lives. But we also know that for survivors of sexual violence in schools, they have been having a Me Too moment for a while. They have learned about their rights. They've learned about their opportunities, and they have pushed their schools to be better. And that is not the sort of thing you can put back into a box so easily. And they've seen what happens when their schools put systems in place that are unfair, and they've gotten just enough of a taste to know what happens when there are opportunities that look a little differently. And they know what it looks like when too few people came forward at all. And for good reason, I think they weren't coming forward because they were being met with systems that were going to treat them unfairly. And they also know what it looks like to have the ability to come forward collectively or individually and be treated with respect and dignity and be given a fair shot in the process. So I have been heartened to see over the last almost 2 months, many schools recommitting to the steps that they are taking and saying that we're not going to take this interim guidance bait. They have said, we'll see what you do ultimately, but we think we were on the right track anyway, and that is not the work. We don't see that as our work, our plan. We've been keeping a list of those schools, if you're wondering. And I've watched to see what the University of Illinois has done. For those of you who are wondering, they have said that they don't anticipate making changes to their policies due to this interim guidance. I think that's a wise step. And I especially applaud all the students who have been engaging and pressing for their schools to be clear and be on the record about what it is they plan to do or not do. I think their leadership is extremely important during this period, because what we know now, really more than ever, is that advocates are at every institution who will also be fighting with us to protect Title IX, and that is really inspiring for me. And that other institutions will be standing together to say that they're going to continue to abide by this work. And I think that we will see that in public and private, in large and in small. So I want to make sure there's time for questions, but I just want to close with the following story about one of our clients, because it's a story that gives me a lot of hope. And this is a student who had challenged her school in a range of ways after she was raped by a classmate. He was extremely popular, and she was pretty scared to come forward. But she knew just enough about her rights. She had read things in the news. She knew just enough to know that she actually could come forward, and she did. She had heard about Title IX, and she actually went to her school and said, I think there's something called Title IX that says that I have rights here. She expected that her school would make it so she could attend school safely, it would do an investigation, and would address the retaliation and bullying that she took for exercising her rights under Title IX. And I'm not going to sugarcoat it at all. She had to really endure a lot. She had to take on a school that actually did not see its role as investigating. She had to take on a school that was not doing very much to address the harassment and retaliation when kids jumped her after school for telling, and for she was called crazy, she was called a slut. She had to take the sort of subtle and not so subtle suggestions that perhaps there's another place that she might do better. Perhaps there's an alternative school for kids who are having problems fitting in at their own school. So she came forward and exercised her rights, but she has endured. She has endured in all sorts of ways, and we are representing her in federal court on this case. And she is someone who now more than ever believes that this is not a thing that can be swept under the rug. I think about the Alexander v. Yale case. By the time her case is resolved, I mean, she's already moved on to college. But she's not giving this up because she knows this is about her, but it is really about the sort of change that is long time coming. It is about encountering a law that applies an equality framework. It is about encountering policymakers who are going to be eager to more explicitly outline their obligations. It is about challenging our culture, which has allowed this to persist for so long, together with these new and exciting mandates that over time, she really believes we'll see a new norm. She really believes that if not for her, that for the next generation, that Title IX's promise of being able to attend school without sex discrimination will be a reality. So this has me hopeful for our clients. It has me hopeful for schools, for students, for survivors everywhere, that Title IX's promise of equality will someday reach a reality. So thank you all for having me. And I think we have a little time for questions.
Exactly, about 10 minutes.
Okay, great.
Yeah.